54, Rico Yates. Morning, sir. This is a case where they're alleging that on this particular date, which is specifically August 24th, 2019, that you, it looks like, left your vehicle unattended. You did have insurance. That's normally a 2-point violation, but the city has amended it so that you don't get any points. How do you plead to that particular charge? All right. I'll accept your plea with a fine of guilt. It's a $100 fine plus costs. I see you posted a bond. When you go to clerk's window, they'll make the application. All right, take care. You're welcome. Jamila Richardson. Good morning, how are you? Good. 12 CRB 00357, they are alleging that there was a disorderly conduct. And Madam Prosecutor, for the record, how are you resolving the case?
Yes, this is a 7-year-old disorderly conduct. Just to avoid her having to come back and be having to dig, and the clerk's office having to dig for a disorderly, I figure at this point, since I haven't seen Ms. Richardson before, we can just resolve it by dismissing it at cost.
Okay. All right, so you understand the case is going to be dismissed at cost only, correct? All right. So Ms. Richardson, I'll go ahead and do that. Go to the clerk's office and be careful going forward. Take care. (19 CRB 01454), Sterling Walker. Or Sterling, I'm sorry. All right, Mr. Walker, this was a charge where they were alleging that you were in possession of criminal tools, which specifically is saying on December 6, 2019, you had a digital scale inside your pocket with marijuana residue on it. And then in addition to that particular charge, they charged you with possession of controlled substance, stating that you had 14 grams of marijuana at the time. So it looks like what the city has done is dismissed one of the charges and reduced the other to a minor misdemeanor, which carries no jail time and a maximum of a $150 fine. Is that your understanding?
Yes, sir.
All right. To that minor misdemeanor, how do you plead? All right. I'll accept the no contest plea with a fine of guilt. As opposed to $150, it'll be $75 plus costs. Just go to the clerk's office and take care. All right. Okay. Charles Lewis. Mr. Lewis, 19 TRC 04774 is from December 11th, alleging an OVI offense, failure to maintain full-time and attention, and a traffic violation. That's for this one, Sanders. And it looks like right now you're going to maintain not guilty, correct? All right, they're alleging here, they circled that there was a urine test taken. I don't have those results, but the officers filled out a 2255 form. What basically what that does is if they send this form to the BMV, even before your case is resolved, your license are suspended. So don't drive now. I don't want you to get into any trouble there. And the defense attorney, did she speak with you about the possible penalties for an OVI? All right. So there's always the possibility of mandatory jail time. And that really depends on whether this is your first one within 10 years or more. If it's the first within 10 years, there are other options, for instance, a class that you can take. But if it goes beyond that, then you're looking at some jail time. But we'll get to that bridge when we make it there. So today, it'll be a plea of not guilty. The pre-trial will be set for December 30th at 9:30. And defendant advised not to drive. Any questions, sir? All right, we'll see you back there. Okay. I see.
All right.
This is for this one. January 17 CRB 00661. Is it Diary? Dier Jacobs. All right, so Mr. Jacobs, remember we were here. We set this date as a pre-trial. I allowed you to leave on a personal bond. I appreciate you coming back to court. Keep in mind, this is an allegation that on or about May 3rd of 2017, you did assault Mr. Hoskins by punching him and kicking him in the body. You're maintaining not guilty, and actually we're going to set this for a trial, and that will be on January 16th at 1:30 p.m. All right, we'll see you back then. All right. Marcus Harris. That's not the one. He's not the one he's telling me about. Good morning, sir.
Good morning, Ron.
Mr. Harris, how long have you been in jail?
10 days.
So you were not able to post a bond, correct?
No, sir. Yeah, I actually just started a new job like a week prior to coming here. So I haven't got paid yet. So.
All right, so you recall that you're charged with domestic violence. They actually put two charges of domestic violence. One, a regular charge, the other one a threat, and then there's aggravated menacing. The domestic violence is alleging that on December 4th, you did knowingly cause physical harm to Charmaine Tamady by striking her in the face. And then they're saying that on that same date, or excuse me, actually, this is the 4th, the same date, the 4th of December, you threatened to kill the same young lady. So that's a domestic violence threat. So you have two charges of domestic violence. Then there's the aggravated menacing, because they're saying on December 4th, while being transported to the East Cleveland jail, you told the police officer that you were going to beat his ass and blow his head off. And then we have aggravated menacing again, where they're saying that you also said that to possibly another officer at the time. And you're 34, correct?
Yes, sir.
All right. So right now, Ms. Conwell, we're maintaining not guilty for the defendant. Is that correct?
That's correct.
Ms. Johnson, you have any information for me on this case?
Ms. Johnson, for the record, I just want to say for the record, I tried to contact Ms. Tinelli on multiple occasions. She has not returned any of my phone calls. The messages, the callback numbers, and I haven't heard anything. I've been trying to attempt to reach her since before December.
And you're pretty sure of the accuracy of the information you have. She's just not calling you back.
That's what I believe. I will continue to try to.
Mr. Harris, do you live? And at this point, the questions I'm asking you right now, we're maintaining not guilty. My questions right now is for me to determine whether to lower your bond or not. So I just need you to be honest with me on some of these questions. I won't ask you anything to compromise your plea of not guilty. Do you live with this young lady?
No.
When's the last time you lived with her?
I never actually lived with her. I just go over there from day to day because that's my child's mother. I live on Knowles, like literally 2 streets over.
Right.
Yeah. So.
How old is your child?
She's actually 5 months pregnant right now. So.
But do you have one that's born by her yet?
No.
So you have a child on the way?
Yes.
All right. All right. So here's the thing. Who do you live with on Knowles?
By myself.
You have any roommates or tenants or anything like that?
Yeah, it's like a rooming house.
So how many people live there?
4.
Are you related to those people?
No.
All right, so Mr. Harris, you understand that any bond that I set, one of the requirements is that you have no contact with her. So even though the two of you are about to have a child, my requirement is that you have no contact. And I know that's difficult. That's challenging because you and I have never met. And I'm standing here telling you not to contact somebody that you have a child coming with. But I'm only giving you that advice for 2 reasons. One is that I have to. And 2, because I know it's for the best looking forward. Because if you contact her, because I've made an order and I have to give you that order, the prosecutor, they will let me know that, or the victim's advocate, and then I would have to give you 6 months for violating my order. And that's before we even get to the case. So I'm saying all that to say, relationships are very emotional, very emotionally charged, but do the right thing. And the best thing for you right now is no contact with her, okay, until you get this case rolling.
I understand.
If she tries to contact you, because you're not supposed to contact her, at the very most, if she texts you or something like that, your response should be, I can't contact you because of the case. Contact the victim's advocate, because she knows that she's calling. So we need to at least get a handle on what's going on. This case may work out really well for you. It may be bad, but it may be well for you if she at least communicates with Ms. Johnson. At some point, we got to know what's happening. Otherwise, I can have you coming back to court month after month after month, wasting your time. So let's not do that. Let's get it resolved. So the court date we're going to set for you is January 19th. January 19th at 9:30. But what I can also tell you, just so you look out for your own benefit, because you live two streets over, if she's contacting you and that becomes a concern, walk over to the court, show my bailiffs the text message or something to defend yourself in that regard. Make sure you stay in touch with us so you don't have to disappear between now and January 19th. But otherwise, I'll see you back on that date.
Okay.
It's December 19th.
December 19th.
That's important.
All right.
That's important because here I would have been expecting you on the wrong date. We issue warrants and all that stuff. So December 19th, which means I'm going to see you next week.
Okay. So is this, am I getting out today? Or?
Yep, you'll be out today and I'll see you next Thursday.
All right. Thank you.
All right, you take care. Thank you, Sandra. I should have known you wouldn't have said it that far out. Let's see if they can read that. Harry Jones. Mr. Jones, we have 19, come on up to the microphone, 19 CRA 01465. This is from December 8th, and the allegations that you committed a burglary offense. Burglary is a felony of the 4th degree where you're looking at the possibility of 6 to 18 months in prison and a $5,000 fine. The complaint states that on or about December 8th, you did gain entrance to the residence of Breonna Sellers and a Mr. Philpott, as well as a Fannie Williams. Trespass in an occupied structure on Melbourne with the purpose to commit a theft offense.
You want me to answer?
No, give me 1 second.
No. I'm saying no. You shouldn't be discussing your case.
Need a new J on that. J on that one. All right. Mr. Jones, how long have you been downstairs in the jail? 4 days. What city do you live in? All right, so here's the deal. They're charging that as a felony, right? And as I mentioned to you, this is a misdemeanor court, which means I cannot keep felony charges here. They have to go to the county. And it's my understanding, I'm going to ask for the record, that you spoke with counsel here, and you are waiving the preliminary hearing, allowing the case to be sent to the county. Ms. Conwell, is that your understanding?
Yes, Your Honor, after discussing with the gentleman, his rights to preliminary hearing is chosen to waive.
All right. So, Mr. Jones, that's not admitting any guilt. It's basically sending the case to the right court. I'm going to set a court date for you, which will be Monday at 9:45 on the 12th floor of the Justice Center. So you understand all of that? And how old are you, sir?
66.
And you live in Cleveland. Who do you live with?
Myself.
All right.
My niece stays in the house.
So your niece stays in the house.
I don't live with her.
Okay. And you may or may not have had permission to be there at the time, right? But you don't have to say that for the record. I don't want you to say anything because I'm not the judge. I don't want you to say anything here that they could pull your records and all that stuff. Just right now, I'm maintaining that you didn't do it. So we're maintaining not guilty. They are recommending a $1,500 surety bond. That means a bail bondsman would be involved, and it's only $1,500. That's not a whole lot. Are you able to take care of that?
Call.
All right.
I'm not at the minute.
I'm sorry.
Not at the minute.
Are you working?
I do a little work.
Okay. So here's the deal. The bond is really low. It's $1,500, right? At least that's, unless they put the comma in the wrong place. I have $1,500 here. See, the comma's in the wrong place, but they have an extra O on the end. So it really could be 15,000, right? But I'm gonna tell you, I'm gonna leave it at 1,500 because I'm gonna accept that maybe you knew the person, maybe that was your relative that lived there, and then I'm reading on the police report, how long, I don't know. I don't even want to know how many days you were there, but I read here when they came in and they discovered you were kind of
I made a statement.
Okay.
A long time. I was saying where I live.
okay. All right, well, that's cool. Well, what I'm gonna say is I'm gonna go ahead and leave the bond at that amount, 1,500. It's a very low bond. Hopefully you can make that bond, but otherwise your court date is Monday. All right. Any questions? All right, you can have a seat. All right, Kamal Townsend. Mr. Townsend, we have 19 CRA 01463. This is a charge of carrying a concealed weapon. Good morning, sir. It's a felony of the 4th degree, 6 to 18 months and a $5,000 fine. And they're stating that you did have on your body or person on December 7th a handgun with 3 live rounds of ammunition. They have a 4-cycle arrest history with no convictions, and you're 32, correct? You spoke with the defense attorney, Ms. Conwell? Ms. Conwell, on behalf of Mr. Townsend?
Yes, after discussing with Mr. Townsend's rights to preliminary hearing, he's chosen to waive those rights.
All right. So, Mr. Townsend, I'm going to also set your court date for Monday, 9:45, 12th floor of the Justice Center. All right. They asked for your bond to be $5,000 cash or surety, which would mean roughly you need maybe 500 or close to 600 to get out. You'll be able to do that? Yeah. All right. So I'm going to go ahead and set that bond for you. We'll give you a reminder of your court date, and you just keep that court date and good luck, all right? Have a seat. Lamar Brown. Mr. Brown, we have 19 CRA 01461 is a drug trafficking charge. They are alleging that you committed a felony of the 3rd degree where you're looking at 9 to 36 months and a $10,000 fine. because they're saying on December 7th, you did knowingly have in your possession a clear bag of crack cocaine as well as suspected heroin. Did you get a chance to speak with the defense attorney?
Yes, sir.
Ms. Conwell, on behalf of Mr. Brown.
Yes, after speaking with Mr. Brown, he's chosen to, and explaining him his rights at preliminary hearing. Mr. Brown has chosen to waive his rights.
All right. So you understand the case will be going to the county. And in addition to that, I'm going to set your court date for Monday. Now, did they tell you what your bond recommendation was? All right. So what they have here is recommended a $20,000 cash or surety bond. Are you able to take care of that?
How much is it?
So a $20,000 cash or surety would normally put you somewhere in around the ballpark of paying somebody $2,000, a little bit more than that to get out.
I don't know.
And how long have you been in the jail?
I've been in jail since Friday.
All right. And you're 30 years old?
Yes, sir.
All right. So look, what they put here as your, they said that you have an 11 cycle arrest history. That means you've been at least arrested 11 times. They have possible convictions of drug possession ×2 and another trafficking in drugs. So Mr. Brown, at some point, you know, I don't have this case. As far as I'm concerned, you're not guilty right now. But at some point, you want to figure out a way to break this cycle of dealing with the drug issues, because obviously, you know, it's causing you to spend time in jail. And I don't want that for anybody, especially, you know, a young man still 30 years old, you have your whole life ahead of you. And then they set a $20,000 bond mainly because of that, you know, your history. But what I'm going to do for you, Mr. Brown, I'm going to reduce your bond a little bit to give you a chance to come out or at least get out of jail and defend yourself. But you got to make sure you make it down to the county. And the reason I'm going to do that is, one is I don't see any here that makes this a violent incident, but it's more so if they're alleging that this occurred, you know, obviously you got to make some changes. You know, you got to make some adjustments. Now, I will mention they didn't charge you with it, but they had some thoughts that the vehicle you may have been in may have been stolen, but you're not charged with that. So I don't know how far that went. So I'm gonna reduce your bond in half. It'll be a $10,000 cash or surety bond. All right. So hopefully that'll help you get out a little sooner. Otherwise, your court date is Monday, 12/4, 9:45. All right. Any questions? All right. You take care, sir. Christina Robinson. Oh, it's the other one. Yeah, bring it up. I have the DV that you were concerned about. It's not up. Okay, I got a case there. Okay, so we can talk to the prosecutor about it. Good morning.
Good morning.
All right, Ms. Robinson, they have a felony charge of having a weapon while under disability and vandalism in 19 CRA 01462. The complaint is alleging that on or about December 9th, you did knowingly cause physical harm to the property that is owned or leased by a governmental entity. That's a felony of the 5th degree, 6 to 12 months, and a $2,500 fine. They're also stating that there was a felony of the 3rd degree, weapon under disability, stating that on December 9th, you did knowingly have in your possession a 9mm firearm that they're asking to have forfeited. That's the possibility of 9 to 36 months and a $10,000 fine. And the reason that they're stating that there's a disability, because if you've had a previous conviction of a felony, you're not allowed to have a weapon. In addition to that, we have 19 CRB 01460. Those are misdemeanor charges of resisting arrest, because they're alleging that you did knowingly resist the officer by pulling away while they were trying to put you in the patrol car. This was on December 7th. And that you damaged the city property, which is the officer's police car, by kicking the center prison window out or causing damage to it as well as the roof. And Ms. Robinson, how old are you? 32. And how long have you been in the jail?
6 days.
All right. You have any children? Okay. All right. And this. Did you speak with Ms. Conwell about the case? Ms. Conwell, on behalf of Ms. Robinson, how are we proceeding?
And after speaking with Ms. Robinson and advising of her rights for preliminary hearing, Ms. Robinson has chosen to waive these rights.
So you understand the case will be sent to the county, correct?
Yes.
And what I'll do is I'll send that resisting arrest down there also. That way you don't have to worry about two different courts. So everything will be sent to the county. Ms. Robinson, they are requesting a bond of $15,000 cash or surety. Are you able to make that bond?
No, not right now.
And they put here for me to review a 10-cycle arrest history with 3 convictions for aggravated menacing and 1 or at least 2 assaults on a police officer. All right. Ms. Robinson, I believe one of the possible reasons why they set that bond so high, and you don't have to speak on it, but they're alleging that you were shooting at a person. That's how the complaint arose, that they responded to that and then found you in the area. So Ms. Robinson, because I don't believe I've had you in the court before with any things or any cases, but I always, I try to, just express some type of knowledge or wisdom from the bench, because you may not get it when you go down to the county. It may just be simple black and white. What did you do? Did you do it or not? Not guilty, or this is your sentence. Whatever is going on, at some point, you got a lot of life ahead of you, still life. You gotta get to the point where the cities, or at least the convictions or the things they're accusing you of, doesn't involve, you losing control of your emotions. Aggravated menacing, assault on the police. I'm not even talking about what they're saying now. I'm talking about the past, because what happens is when they run that and they see that, then they approach you. They're going to approach you in a certain way, even if you don't deserve it today. They're going to approach you based on what they see. So you got to be able to show them a whole nother side, not the kicking and punching and destroying stuff. That way, I probably would have seen you. That causes them to delay your paperwork and all that stuff, and you sit down in the jail longer than you have to. So, at some point, you got to work on that. But it's not guilty right now. Everything will go down to the county. The bond is $15,000 cash or surety. Your court date is Monday, 9:45, 12th floor of the Justice Center. All right? You can have a seat unless we're done. All right, I think we're done to this afternoon. Then we have several trials this afternoon. So Ms. McCullough and Ms. Johnson, Bailiff Sanders brought to my attention Thomas for this afternoon, stating that the complaint mentions strangulation twice. Yeah, so I'm wondering, why don't we submit this as a felony as opposed to bringing them up?
When they first brought it to me, I took it right back to Detective Stanford. He said the guns didn't belong to him, the guns belonged to the guy that owned the house, and whatever else. They just didn't think that it was gonna be accepted.
So this is one thing I wanted to mention to
She
you.
didn't lose consciousness or anything like that.
Well, this is what I want to mention. When I went to, because I know that our police department kind of sometimes gets lazy with that. But that last seminar I went to, because they were all worried about it.
Start using the word term strangle.
Yeah, but you can actually, you can send it directly to you can actually communicate directly with the prosecutor on these, because what they're doing is they're putting pressure on me as the court, and how we handle them. Whereas we know sometimes it's the complaint, the way it comes in, and the way that the police report's written up. So you don't have much to offer or work with. But if we feel that it should be a felony, you can actually contact that prosecutor yourself, as opposed to having Ernie do it. Because Ernie may know somebody, how he gets sometimes, gets all sympathetic. Meanwhile, we got in the
I
complaint
didn't
two
get the
strangulations.
impression it was sympathy. He just didn't think that she would take it based on that. And it looked terrible. It read bad.
And Samara, have you spoken to the victim?
Yes, I have.
And that was the other thing. That was one other thing. He also said that she really didn't want to press charges or anything.
Is that what you got?
That's what she said. Exactly.
That's not
But-
But it's a headache when you're trying to go forward with something and you can't get your victim to cooperate.
And the child called
Which my next thought was,
headache.
and that was my next point. So you go leave it here so I can have a headache?
Yeah. Yeah, I would say, yeah, I'd say we should send it down. And I got to figure out who is the, let's see.
Deborah Obed is the
Yeah.
person that they always contact.
And you know what, that way, Heather, and you and I as lawyers, because he's, Ernie's not,
Oh, no.
we'll be covered. And even if she sends it back, you can put on the record, hey, I sent it down. I talked to her directly or sent her an email. She sent it back and then we're good. Then we'll just deal with it ourselves. But at least we can try that.
Okay.
All right. I appreciate it. But we'll hold him until then.
All right.
All right. Thank you.
You know,